This panel aims to discuss the law and the regs, the developments that affect M&A. And it has probably the distinction of being the first super sophisticated assessment of the new world that we're going to be living in with the change of administrations at the beginning of next year. Presumably, well, the assumption is that there will be a change in attitudes about M&A, about the desirability of M&A, about antitrust policy, perhaps, change in the FTC, perhaps, and so change in the notions of cross-border M&A, cross-border investment, perhaps, and this panel of really terrific folks is going to be discussing that. So the theory is that each of them will talk for a bit, presenting their views, and then discussion among the panelists and discussions with you about the new world. And so we're going to do this in a sort of a thematic way with an initial overview of the landscape is Maria Raktis, a partner at Skadden Arps, who has the distinction, I added it up, of having advised about $250 billion in deals, including the activism deal. Maria, the floor is yours.
Thank you. Thanks for having me. It's wonderful to be
Wait, I think your mic, you need to turn it on.
Perils of being the first speaker.
Great, thank you.
I was just saying thank you for having me. It's always wonderful to come back here, particularly on the first coat and umbrella day. Really enjoyed that. It's good to be on the panel with all of my sophisticated colleagues. I think there's an expectation that the Trump administration is going to take a more hands-off approach, to put it mildly, to policy and regulation to facilitate a more business-friendly environment. And that should logically translate into less aggressive antitrust enforcement. We've had, I would say, the most active antitrust enforcement of recent memory in this last Biden administration. The current leadership has investigated many more deals, more deeply, brought more cases. Certainly there's a perception among some that a tax was being imposed on merger activity, and particularly big deals in certain industries, tech and healthcare. But I think I would encourage folks to think of it not as just more enforcement. The current leadership has really attempted to widen the lens of antitrust and explored many more theories of harm. They passed new merger guidelines which reflect that philosophy and that thinking. And that all contributed, not just the volume, but the tenor of it contributed to the perception of very aggressive enforcement. Now, as we shift to Trump 2.0, obviously the antitrust appointments at the FTC and DOJ will be important, and they will tell us more about the direction of antitrust policy. But I think it would be a mistake to assume that there's going to be a major about-face in antitrust enforcement. And I say that for a couple of reasons. One is people who don't follow this as closely probably don't recall that the Google search case and investigation was brought initially by the first Trump administration. The Trump administration also brought a case against Facebook. So a lot of what we're seeing now play out in the courts and the press really started out under the first Trump administration. And as people say, it was not your grandfather's Republican, sort of traditional Republican antitrust approach. And in hindsight, it was quite active. They also brought the first vertical case in 40 years. But I think something that just doesn't get talked about enough is how much the current leadership has encouraged us to think more broadly about what can be a competitive harm, or what a competitive deal or practice really looks like, and how to use merger review to really investigate those things deeply, the tools and the process. So it's possible, in my view, that some of these more novel theories and approaches, like harm to labor, maybe conglomerate, harm from conglomerate, deals that bring together many different products or services into a particular portfolio, and the process changes, that some of those things will continue to be pursued in the next administration and maybe repurposed in pursuit of different policy goals, and maybe even in goals that we can't fully anticipate sitting here today. So to get a little bit more specific, I would say that for decades in my practice area, there was a lot of consensus about what should antitrust be and what are the goals, and administrations would either dial enforcement up or down, but the ground rules remain pretty stable. There's a focus on keeping prices low and output high, and I think what Chairwoman Khan and Jonathan Cantor have done, and the current administration have done, is really put antitrust front and center. Antitrust never even got a mention in campaigns, really, when I started out in this business. But the current leadership argued that not only has policy been too permissive, but it's been too narrow. And Chairwoman Khan, I would say in particular, has said the focus on prices and output keeps us from seeing other harms and keeps us from seeing other ways in which consolidation can harm the economy and consumers and all kinds of things, social harms. So much more emphasis on not just vertical cases, but as I said, labor and potential competition, things like that. So I think the main question is there going to be more of a reversion to this, what we call traditional antitrust, which I think people might quibble with, but is there going to be a reversion to that and a rejection of the ideas that we've seen over the past couple of years, or is there going to be some assimilation of those ideas in a new form or format? And I really think that's the question that I'm most looking for the answer to, and excited to see what's going to happen. To be a little bit more pragmatic, I would say that overall it is likely that we will see the regulators stay closer to more mainstream antitrust principles in most cases. I think there will be significant exceptions. There is some speculation that the new merger guidelines that I referred to earlier, which reflect and try to formalize this new broader approach to antitrust, that they may be rescinded. I think that there is some possibility of that, but I could also see them remaining in place, with the regulators just opting not to pursue or not pursue as strongly some of the presumptions and more novel theories of harm. I do think that there will be less emphasis on very novel cases that push the boundaries of the law. But one possibility certainly is that some of the ideas could stick around and be used for other purposes. I could easily see, for instance, the new administration giving more attention to acquisitions by foreign interests. And certainly there are other mechanisms for focusing on national security concerns. You're going to hear about those. But I just don't see any reason why Trump 2.0 could not opt to focus on national interests and that agenda more broadly, using the FTC and DOJ. To be clear, I'm not predicting that, but I do think it's a possibility. A couple more things. I think remedies for mergers is something that Chairwoman Khan and AAG Cantor have said they are not in favor of, the sort of sue, not settle mentality. I think that will change. The bar, however, for remedies will remain high. I think you'll see potentially behavioral remedies make a comeback, but continue to not be favored. I think divestiture remedies, we're going to have to show that they really can solve the problem, because that was a concern that I would say was bipartisan even before some of the seesawing that has happened. And then I would say, some of the things that might stay the same or stick around. We have all these new HSR rules. The filing is about to get more onerous, more business documents, more need to stake out positions in the filing itself rather than just putting in financial data and documents. There was Republican support for those changes, scaled back version of those changes. Some folks are wondering whether that new filing will be delayed or, again, rescinded. I think because there was some Republican support, it's likely that stays in place. The good news is that early termination for deals is back. I think that will help business folks and deals get done. You will continue to see the focus on tech and healthcare. Those are just too important to our economy and to consumers. I think you'll continue to see state attorney generals be very active in antitrust. If there's a significant scale back in enforcement by the federal agencies, certainly state AGs can continue to pursue mergers. They have the ability to do that. I would say, though, that historically, the states have relied on the federal investigations in pursuing those cases. And so it does introduce some complexity if the states would have to expend a lot of resources, investigative resources, and most don't have the power of the HSR Act to go about it. And the last thing I'll say is, one of the biggest thorns in my side over the past 4 years have been competitor complaints. It used to be that if you wanted to complain about a deal as a competitor, the advice you would get was, look, if the merger really is bad for competition and prices go up, you, competitor Y, are going to benefit from that. And so anything you say will be taken with a grain of salt. In the last few years, there's just been a tremendous amount, because of these newer ideas and theories, there's been a tremendous amount of ability for competitors to lodge complaints about deals. In fact, you mentioned Microsoft Activision. That's a case that I worked on. A lot of that centered around Sony as a competitor to Microsoft, and Sony actually had the lion's share of the video game console market. So a lot more traction for competitors to lodge complaints. I see that as continuing, maybe for different reasons, not necessarily for reasons having to do with theories, but for reasons having to do with a belief that there's a certain amount of influence. So I think with that, maybe I'll stop. I don't know if we want to go to questions, or I think Michael was going to also make some comments.
Follow up with Michael. Michael Murray, Paul Hastings, is the co-head of their antitrust group. He's a Washington person, not a New York person. Worked in the Justice Department, where he was a first DAG in the antitrust division. So I suspect his perspective on matters like the new Hart-Scott-Rodino rules, and other ideas that come from being a Washington person living in the new environment for antitrust. So, what are your thoughts?
Sure. So thanks for that, and great to be here and see everyone at this event. I'll make 3 points. First, what I'm expecting. Second, what I'm seeing, which is loosely correlated with what I'm expecting. And then third, a few changes that are sort of underlying that that Professor Gordon mentioned. So first, in terms of what I'm expecting, I think we're entering a new world of antitrust where companies can expect a few things. First, a little bit of a return to the rule of law, increased predictability, and also a targeted focus on industries of particular concern to the American people overall, as opposed to all industries. Second, and this is what I'm expecting, we are seeing increased M&A activity. I think you heard that this morning, and increased requests for advice about how to navigate the nuances of this M&A environment from folks who sort of understand the incoming administration and the transition that is already going and that we're all reading about in the news essentially daily. And then third, I'll talk a little bit about the changes that we're seeing, the HSR changes that Professor mentioned, and also some of the changes at the FTC that Maria alluded to. So first, in terms of what I'm expecting in terms of the changes. Overall, Maria and I are actually in agreement on many of what we're saying. I actually have written in my notes here, this is not your father or grandfather's antitrust. So we're very much in agreement, although I have a somewhat nuanced perspective from having been in Washington. The first is I think we will see a return to sort of more rule of law type initiatives within the antitrust division. And what do I mean by that? Because that sounds sort of like big and abstract. I realize we're on a university campus, but I would like to make it a little bit more concrete. So the current enforcers, as Maria alluded, are focused on expanding the scope of antitrust law. And a lot of that in practice means turning to older precedents or doctrines, particularly 1960s, 70s era Supreme Court cases, circuit court cases, that have been somewhat or even entirely discredited with the passage of time and had not really seen the light of day in antitrust law for several decades. So I think the new administration will likely abandon reliance on those precedents and those doctrines. Second, I think you'll see, and Maria also alluded to this, or I'll say it a slightly different way, the less of a use of process itself as an investigative tool to kill deals. So it's useful to investigate deals. When I was at DOJ, there were many deals that were deeply concerning, and we brought the largest vertical merger challenge in 40 years, the Google case, a Live Nation case, many cases that have continued in the current administration. But we did not think that it was useful to use the investigative process and the delays that come with that process as an enforcement mechanism itself. The investigative process and all of the burdens and costs that imposes on companies are useful to decide whether to enforce the law, not as an enforcement mechanism in itself. So I think we'll see a change there. In terms of increased predictability, I think you'll see the return of some of the guidance and guidelines that had existed for several decades, whether that means pulling back the recent merger guidelines, reinstituting the remedies guide that came out in the last administration, possibly reinstituting some of the information sharing guidance that had come out in the 1996, 1997 time period that had sort of stood the test of time, and some of the business review letters that had been issued that have since been repudiated. I think you'll see more of those kind of guidance documents that help businesses to try to navigate the antitrust environment and sort of have established mechanisms and processes to say, okay, I know I can do this, but I can't do this. I know I can do that, but I can't do this. So I think that's true. But all that is to say, I don't see a sort of wholesale reduction in enforcement across the board. So as Maria was saying, this is not your father or grandfather's antitrust. This isn't 1984, 1982, or 2002 all over again. As has been mentioned, there were quite a few large enforcement actions in the previous Trump 1.0, I think people are calling it these days. And a lot of those activities were in industries of significant concern to the American people, whether that's sort of Google search, whether that's Live Nation, other types of activities. NCAA is a good one that also comes up to many people in a somewhat niche area for those who are interested in sports. And some of those enforcement actions were somewhat novel or aggressive in their own way. So for example, in the credit card space, there was a Section 2 monopolization theory added to a Section 7 merger theory in a case, and that hadn't happened in quite a while. So I think we will see some enforcement. At the end of the day, there is a sort of personnel as policy. You know, I'm from Washington, so I'll parrot the old Washington phrase, personnel as policy. And we will see, it will depend a little bit on who the nominees are, and we don't really know that at this point. You know, I don't think, sort of roughly speaking, in the Republican Party, there's essentially a divide between maybe you would call it sort of President Reagan, President Bush II sort of view of antitrust, and sort of maybe a more, you could call it Trump 1.0, you could call it a Senator Lee kind of version of antitrust that's a little bit more nuanced in terms of enforcement. I think you're unlikely to see a return to the first, and likely to see a nominee from the latter. That said, there's a lot of people out there who are really in the former but sort of pretend to be in the latter, so that's kind of an interesting devil in the detail sort of situation. So that's kind of how I see it in terms of overall framework. I did want to talk a little bit about a couple specific things, and Professor Gordon alluded to the HSR rules. They're a very interesting case study in how old and new antitrust have sort of come together, right? So that was a 5-0 vote at the FTC. So that means all the Republicans, all the Democrats voted for a modified version of what had been proposed earlier in the federal rulemaking process. And here we see an interesting combination of, you know, APA, administrative law, and also antitrust kind of coming together. For me, as someone who was an APA person before I became an antitrust person, this is like my dream issue to talk about. So we have federal rulemaking, notice and comment rulemaking, and potential litigation over a rule that involves antitrust. Wow, this is great. And so what will happen with that rule? A lot of clients are asking us that question. And there's a couple different ways forward. It's past the time for the Congressional Review Act, so even though both houses of Congress are in the same hands as the president, that's not really an option. So really their options are rescind, delay, hope for a friendly suit if they don't like it. But it's not clear that the new folks won't like it. And so there's a lot of uncertainty there in terms of what might happen. The calculus for the challengers to that rule, to that HSR rule, which essentially requires submission of more documents, more statistics, more information as a goal of sort of furthering increased investigations based on the initial filing of the HSR forms. The challenges of that, who range the gamut from strategics to funds to investment companies, the calculus has changed with the new administration. Before, maybe they thought about challenging the rule, but it was a 5-0 vote in the FTC. They would have had to pick a venue and try to find a plaintiff. Now that suit might be viewed differently by the incoming officials at the FTC, and often in a change of administration, you see a sort of a suit and then potentially a loss initially that's not appealed by the agency because the priorities of the agency have changed. You saw that in 2021, saw it in 2017. I'm sure you saw it in 2009 as well, although I don't recall that as well. And so that's sort of where we're heading on the HSR issue. From the FTC perspective, we'll also see a shift in personnel most likely. I don't want to retread the ground that I previously covered, but one interesting thing to keep an eye on, I think, not only in the merger space per se, but it sort of touches on mergers, is a lot of the 6B type studies that the FTC has done in the past sort of few years, which are starting to bear fruit in some enforcement actions and also some merger reviews because the agency is able to learn and think through those issues, whether that's in the supply chain or the healthcare space or even some of the technology spaces. So I think we'll see as that comes out that some of those studies were consistent with the priorities of the new administration, and some of them won't be consistent and they'll just sort of die on the vine, whereas others will sort of seem reinvigorated. And the new administration will, like the current administration, seem to be picking up on its predecessor's priorities, when in fact there's just a broad agreement or broad consensus on a few of those areas. So with that, I'll pause. I think I've probably said a lot, maybe too much, and we'll let others.
Okay, so am I on here?
You are.
Yes. So we now turn to Ivan Schlager of K&E, who's probably one of the nation's leading authorities on CFIUS and the idea of foreign investment in general, including the fact that as the chief counsel of the Senate Commerce Committee, he was involved in the implementation of Exxon Florio. So his knowledge is extensive and deep and goes back a long way. So, Ivan.
Yeah, I drafted an obscure piece of legislation in my youth, and it ended up paying for my children's education. So, what's the scariest phrase in the English language? We're from Washington, and we're here to help. So we'll try to be somewhat helpful. I'll make 5 points, and the point that you made, I think, is really important in Washington. You know, Tip O'Neill used to say, "All politics is local." All politics is personal, and particularly in the regulatory environment. So you think about the CFIUS agencies. 11 agencies operating under consensus. I mean, what can go wrong? Who sits in what chair is going to be important. So Mark Rowan at Treasury, probably going to be a little more powerful in that 11 agency process than Janet Yellen at Treasury. Mark Rowan probably going to be more powerful than Pete Hegseth if he gets nominated. So, you know, who's in what chair matters. Democratic administrations are run by lawyers. Trump administration tends to be run by one guy who tweets a lot, and he has personal opinions. Let me give you an example. Take TikTok. Donald Trump signed an order to divest TikTok. Donald Trump on the campaign trail, when his friend from Susquehanna, who's an investor in TikTok, suggested maybe he shouldn't do that because it will give Facebook a monopoly, goes on a rant and says, I'm not going to shut down TikTok because Zucker Schmuck needs competition. So something to pay attention to in all of this is you run an interagency process. Lawyers do their best to try to do it, you know, through the right regulation and the right regime. The president, and this president, has firmly held opinions, and he's a deal guy. Also think about, what role does Elon Musk play? And here's my second point. You know, if there's one issue with bipartisan consensus right now in Washington, it's China and the need to decouple from our dependence on China and the supply chain risks that Chinese vendors potentially have as a national security threat. And you're going to have a lot of Chinese hardliners in the administration. Marco Rubio, hardliner. Waltz, the new national security advisor, hardliner. Bob Lighthizer, our former partner, my mentor, the guy who brought me to Skadden before I went to Kirkland, a China hawk. Juxtapose the outsides position that Elon has now in the administration, and somebody who's more dependent on the China market, both for manufacturing and for sales. So, you know, it remains to be seen how all of that plays out. One thing that I would say is, what will continue from the previous administration to this administration is the CFIUS process is now being used to address supply chain risk associated with China. So if I'm a European semiconductor company and I have critical dependency on China as a market, or I'm doing joint R&D with China, they're going to use the CFIUS process now as a way to limit the US exposure to that China connection. So it's something to pay attention to. The third point is the 1980s called and they want their trade policy back. Because CFIUS, for the most part, has been a narrow national security review with an assessment of what's the risk associated with the foreign buyer, what's the risk associated in the vulnerabilities with the asset that they're acquiring, and can that risk be mitigated? And it was really very deal specific and deal focused. And I think, depending on what role Lighthizer plays in the administration, and I would say Bob's acolytes, because I think a number of people who are trained by Bob will be in the administration, CFIUS is going to be used as a trade policy tool. And actually in the 80s, that was part of our thinking, which was, it was part of the 88 Trade and Competitiveness Act. And Foreign Direct Investment Review was part and parcel of export control reform, creating semi-tech and promoting the US semiconductor industry, and then giving the US trade representatives certain tools to open markets, Super 301, 301 authority. I think what you're going to see in this administration is using CFIUS as one of those tools. So if we have a bilateral trade dispute with France or Germany, and you're a German or French company doing an acquisition in the US, chances are that bilateral trade dispute is going to be part and parcel of your review. The tariff regime. If you're, whether or not in how we're doing tit for tat on tariffs, that may be part and parcel of your review. And then the final piece, if you're a European defense strategic, this is an opportunity for the administration to put even more pressure on, are you meeting your commitment to NATO? Are you at 2.5, or higher in your defense spending? So if I'm a, European defense company doing acquisition in the US, I'm pretty sure I'm going to get asked questions about what's your, spending commitment to NATO. Fourth point is mitigation and enforcement versus facilitating deals. This administration has been run by enforcement people, and they've been very focused on imposing national security agreements and then issuing fines for failure to comply. The Trump administration, far more deal focused, and again, I think Karsh or Rowan at Treasury are going to be more deal focused. Final point, sovereign wealth funds and private equity. This administration has been very focused on Middle Eastern sovereign wealth funds, Singaporean sovereign wealth funds, the Middle East, the ADIAs, the Mubadlas, the QIAs, the PIFs, Singapore, GIC, Temasek. They've been focused on using the CFIUS review process to send some messages about their relationships with China, their access to technology platforms, even some foreign policy issues related to, particularly with PIF, related to the Saudis. When I started by saying all politics is personal, I don't know if you saw Trump at UFC this weekend. Who
I
was
wasn't watching personally.
Hey, what can I say? I'm a UFC fan. You got to be more, Marie. You got to be more of a person of the people. Who was sitting next to Trump? Elon on one side, and Yasser, who runs, the PIF, the sovereign wealth fund in Saudi Arabia. I was in Saudi for FII the week before the election, and the Saudis, they were giddy. I mean, they've been having difficulty getting through the CFIUS process in this administration, and Yasser is sitting next to the president at UFC. They might misread that because at the end of the day, the deep state and the bureaucracy still control the process, and they're probably not going to be, they're not going to change on a dime. But Yasser's ability to call the White House may actually change the dynamic for...
Somebody really wants to get in touch with you, Ivan.
It's the Saudis. No.
It's a sovereign
They
wealth
heard
fund
me.
Or maybe Trump.
Yeah, well, very nice guy. He's been very good to the Trump. Anyway, I think for private equity funds, particularly with co-invests in sovereign wealth fund co-invests, I think the process may be a little more streamlined and a little smoother. So I'll leave it at that.
Can I ask a question? And I know maybe this is not the format, but in light of Ivan's comments, I wanted to ask about something Michael said earlier, because I agree that as a practitioner, what I've experienced is a lot of process and attention to termination dates and agreements, right, relative to how long is this deal going to be reviewed in Europe or by the CMA, and what does that mean for our strategy here at the FTC or DOJ. So I agree with you that there's been more use of process. But I guess what you're also hearing from all of us, right, is more of a focus on American interest, or you said, personal opinions. Maybe it's just priorities. And so my question is, hasn't it been normalized to use process in this way? And isn't there the opportunity for Trump 2.0 to take those ideas, those tools, and use them to pursue those interests? And why wouldn't they?
Well, and the flip side too would be, take a look at everything I just said about, bilateral trade disputes. Rest of the world antitrust, Chinese, SAMR, for example, or rest of the world FTI. So, a number of the cases that we're doing, you got a joint CFIUS review in the The Germans are still upset at listening to Merkel's conversations, and every tech deal I do in Germany gets heavily regulated because of an unfortunate incident. But I think, you know, there's always that possibility to make the process more difficult because of the unique personality of the new president.
So we'll now turn to Dave Curran, who does ESG at Paul Weiss for summary of how that world will change for ESG concerns relating to M&A and otherwise.
Yeah, I'd want to, before I do that, I do want to, yeah, first of all, you got to get you more things to do on the weekend. I've been seriously watching what Trump does at USC. I think it's curious. I wanted to go last because I'd love to hear the experts talking. I just find it fascinating to hear the comments, return to the rule of law and predictability in association with this coming administration.
I agree.
Oh no, I did.
Number one,
I
I find that unfathomable, having lived through the last decade. And why I say that is, and the other I think is we have such a core, and Ivan, you mentioned a number of these global issues. These large companies that are colliding with these issues have these worlds. You know, companies don't. U.S. lawyers focus on U.S. law. And in the case of sustainability and ESG, the U.S. securities lawyers and the U.S. governance bar has been giving advice for a long time around deals and other flow that I think is just completely out of date and out of sync with the reality of what goes on at companies, which we haven't talked about. So I'm a lawyer, but I've spent years inside. I was on the business side, done dozens of deals, and I think lawyers assume that people sit in a room and say, how would Trump look at this deal, and would he approve it, and would this administration? It's not how it works. The business aspects might actually be more important, whether there are synergies, particularly in the private equity world, where a lot of these deals don't surface publicly until very late in the game. And I'd like to think about how companies are looking at the sort of the tree that didn't fall aspects of deals. The criteria that we see clients using, even before the governments are involved, in terms of whatever you want to, ESG is dead, long live ESG is what I've been hearing. So throw aside the acronym. All deals today that we're seeing of any material nature are focused on sustainable issues. All of them, not some of them. And sustainability means whether or not the reputational risk issues are going to be impacted by the concentration or merger of companies. And in that context, there have been companies that have really done a great job of maneuvering language to satisfy regulators, to satisfy constituents, but the same goals are there. And I think it's going to be really interesting to see the administration. The other thing I'm very, and I'm not a Washington insider, thankfully, but in any administration changeover, it's not like on day one, you have all these people ready to go and they're up to speed. This is going to take months, maybe years, to put appropriate people in place. And the current administration haven't been able to staff, for example, in the SEC, even though it's enforcement folks, they haven't been able to staff with enforcement folks. And I think the same is going to be true. It happens in every administration, especially one that has a limited duration. This is not going to be a two-term president unless the Constitution is amended. So we have 2 years, or give or take, maybe 2.5 years to see what happens. And that predictability issue, I think, is really the biggest challenge that we see for companies, because these deals grind, and they have to plan for the post-merger integration, and whether or not these businesses will realize the value for the stakeholders that they have planned. And so I think the biggest challenge for lawyers is advising clients on what it's going to be like in 2 years, which is when that, if there is a regulatory review, ultimately the outcome will take, no matter what administration is, they can't wave a magic wand and make deals go through in 60 days. And so I think that's number one, is the realities of the timing. In the world of sustainability, disclosures, mandatory disclosures are taking over from voluntary. So for companies that have made climate pledges and human capital commitments, for the most part, these were voluntary and people weren't keeping track, and it was difficult to find out what companies were doing in this respect. The CSRD, CSDDD in Europe, there are going to be a series of disclosures that are unprecedented for these global companies doing deals in M&A. The quants are out there. The panel before about activists, folks are taking a look at what companies are submitting to the government. They're taking a look at what they're submitting in public disclosures. And I think the consequences on competition that Maria referenced are going to be one of the more significant ones, because competitors are going to have access to information that they never had access to before. And they're going to play on not only competitive issues, but issues that can harm the reputation of these companies who have made these commitments and may not be able to live up to it. And I'll give you a specific example. I was talking to a general counsel friend of mine, major publicly traded, high-profile consumer product company that has the following claim on its products: made from 80% recycled material. I see some smiles. I don't know anything about recycling, but I do know people who do. And to get an 80% recycling number is almost impossible, certainly for anything anybody would use. And so I called him up and I said, I'm going to bet you that the best dinner in New York, that's not accurate. And he said, oh, I'm sure it is. 10 days later, he sheepishly got back to me and said that, yeah, there's a little problem with the numbers. And I said, how little a problem is there? What can you support? Maybe 30%. So the lawyer reaction, what do lawyers want to do? What's their immediate reaction?
Typo.
Better than
old school club.
Yeah, we've got to get it. We've got to take it off our products. We have to immediately. Yeah, my next assignment for the GC was to go back and find out how long they'd been saying it. 11 years at least on products in television advertising and shareholder reports, all of their proxy materials. Life's not that simple anymore. So I think the lesson is we don't control the microphone, lawyers, and the U.S. doesn't control. Even no matter how powerful Trump is, the EU has a lot to say in this regard, and European standards are forging ahead in this area. And we're seeing, I mean, just in the last 5 years since I set up this practice, the sea change in focus in the M&A diligence process on sustainability issues is from 0 to 60. Issues that, and by the way, AI is included in this mix. We haven't talked about that here. It's a huge issue. What is responsible and ethical AI? How are companies using it? This, I believe, I don't know the administration incoming as well as you do, but I think this is going to play a big role in deal making, because we're going to be able to connect dots that have never been connected before, and you're not in control of the dot connection. The quants, the hedge funds, the folks who are out there are going to be really attacking these numbers, including attacking potential transactions, M&A transactions. I think that's where the action is going to be, even as much as the government.
No, look, I think in our area in particular, deal by deal, we're imposing requirements and limitations related to cybersecurity and AI because of the significant national security threat.
Right. Yeah.
I mean, before we get to sort of antitrust stuff in a general way, I want to ask Paul one specific issue.
Dave, but that's okay.
Dave, sorry.
These are the Paul Weisses.
Exactly.
Paul Weiss,
Yeah.
Dave.
Dave from Paul. Anyway, so about disclosure, it seems to me in the new administration that probably the climate change disclosure rules will be withheld, I would guess, right? Given the influence of the fossil fuel folks. But you had alluded to this. To what extent will the European rules lead to disclosure by most large U.S. firms who will want to do trade in Europe? And what percentage of U.S. firms do you think that'll be?
Yeah, it's a great question. The SEC rulemaking, in all likelihood, it's in litigation and on hold today, in all likelihood won't happen. I don't think that's a rough guess. But it's also largely irrelevant. So companies are already disclosing. They have been for other stakeholders for a very long time. There are international groups, the ISSB, that are trying to consolidate how companies report. I always look at the realities of what are the big four doing, and I follow what they're doing. Well, what are they doing? They're staffing up on ESG and sustainability auditors, controllers. It's one of the fastest growing positions in companies in their control mechanism. And why is that? Because the information is already out there. These companies have been doing sustainability reports. They've been doing all sorts of website, and the SEC has looked at these things. The Europeans are forging ahead. They're continuing to require disclosures, and virtually every one of the large US companies that has significant European operations is already in this boat. The other is the states. You know, for those who are familiar with the regime in data privacy, the US Chamber and others successfully derailed a national data privacy standard, and look where we are. As a result of not having a national disclosure, a national regime on privacy, we have 50 states plus the GDPR, which now governs US-based companies. And we're probably heading in a similar direction in climate. So we're going to have European regulations that US lawyers don't really understand for the most part, because they didn't grow up in this. It was driven from Europe, not driven from the US. And it was driven by consumers of all crazy people. And NGOs who set up these standards that are now adopted by regulatory mandate. And so very different way of approaching things. We have California's disclosure regime, which is now in effect. And I think one of the things, Jeff, is that lawyers tend to say that becomes effective in 2026, 2027, the CSRD. It's in effect now because the reporting is for retroactive disclosure, like financials. So companies that are, quote, preparing for disclosures in 2026 are doing that based on information that they have today. One of the things that is very interesting in the M&A process, when you do diligence in this area, which has really changed significantly in the last few years, is you find out these aren't as I used to joke, the SASB is not FASB. The level of rigor around numbers associated with climate and related human capital disclosures. Human rights is going to be a very big issue. Maria, you alluded to. I think these are the labor issues are going to be very significant in the coming years. There's a lot of unrest. This is only going to be, I think, exacerbated by this administration. So you're going to see private litigation. You can see states litigating around deals to stop deals for different reasons. And then you're going to have consumers, employees, and other stakeholders reacting to these disclosures, because historically, a lot of this information just simply wasn't available anywhere. I think that's the thing that lawyers have overlooked, is that once this information is available on supply chain consolidation, on competitive information, folks are going to have a field day picking it apart and finding out. You want to talk about antitrust issues. You're going to see concentrations. You're going to see power over supply chains that you haven't seen before because it's never been disclosed. In the case of climate, that's very active. So I think we're going to see a lot of litigation and a lot of agita is an official legal phrase on this.
Thank you. Let me ask a couple things. First about global M&A. So one of the drivers of M&A over the last 15, 20 years have been cross-border deals. And indeed, there's been almost sort of a laissez-faire approach to cross-border M&A. The assumption that these deals were for economic growth, and that the mercantile concerns, the trade concerns were second and third order. The national security concerns, at least among our friends, were sort of second and third order. So the question is, to what extent is that benign environment for cross-border M&A going to change, either because of the engagement with trade policy, and or because concerns about the national security / supply chain issues, and or because of idiosyncratic factors involved in who gets to make decisions about these things. So that's really for I guess
look,
for the three.
I think on the national security issue,
Yeah.
You know, we've over the last 5 years seen it become increasingly important, not just here, but actually in Europe. So, in using the national security review process as a way to deal with vulnerabilities and mitigate pre-existing risk and vulnerabilities. I don't think it's a deal certainty issue, but to Maria's point, it is a timing issue and people need to think, do I need to set up a separate subsidiary? Do I need to have a cleared subsidiary to deal with the host government? I think it's always existed. Like, take a look at Sanofi CDR, something that we're involved with now. I mean, in a very French way, now the French state is going to take a position in that deal and make the company. They're raising a national security issue. It's not really a national security issue. It's really more of a French domestic issue. I think we're becoming more French.
Yep.
I think we're asking for and you'll see it in the Trump administration, we'll ask for onshoring. We'll ask for, and here's the last point I'll make because I think it is important, to the point I was talking about earlier about the 1980s. We need to protect processes and technologies that are important for the national security, be it, you know, foundries for the semiconductor industries, process technology for GaN chips, things that we're no longer comfortable going overseas. I think that companies are now going to have to enter into agreements to maintain technologies and processes in the U.S. And
that's going to affect the economics substantially, right? Because they went offshore for a reason.
You know, I mean, I think back to, we did the Alcatel-Lucid deal in 2006. Took 8 months to get through, with, you know, every switch network in the United States and the software that ran that network being at issue. It still is my favorite provision in any national security agreement. Let's just say, to your point about our allies, we have frenemies. You know, nobody engages in more signal intercept and industrial espionage next to the Chinese than the French and maybe the Israelis. The Alcatel agreement, this is 2006, had a provision that said, if you act at the behest of a foreign intelligence service, it shall be deemed a material breach of the agreement and will reopen the review of the transaction. So, you know, some of this, it's been there before. I think it's just going to be, scrutiny is going to be enhanced and increased. Did that answer your question?
Well, it starts. So, other reactions? I mean, cross-border M&A has been a huge part of the dealscape, and the question is whether that dealscape is going to substantially shrink because of, you know.
No, I don't think it shrinks. I think it grows because he wants to make America home again, and we did a deal in the last Trump administration where somebody re-domiciled in order to get through a regulatory review process. But the way we navigated it was, during tax reform, CEO of a very major company decided, I'm going to re-domicile, I'm going to do it in the Oval Office next to Trump. And he said, I'm making America home again. And I think, you know,
Yeah.
they want the validation that America's a good place to invest.
But is your question really to the complexities and the conflicts of interest, right? If we become more American interest minded, or even all the way to protectionist,
Right.
and everyone else has the ability to do it through their antitrust or FDI or CFIUS type reviews, do we get into, I mean, people will find a way to get deals done. We just have to adjust to that, I think, and account for it. But it does increase the complexity.
Let me give you an example, to your point on protections, of Japan, and how the activists have played a major role in transforming the Japanese economy. No activist is actually ever going to own, we saw this play out, never going to own Toshiba, never going to own Hitachi, never going to own one of the big Japanese trading companies. But in order to enhance shareholder value, the Japanese government is making them divest smaller subsidiaries. And it's been a great opportunity for U.S. private equity to pick up. So I think the head of KKR said the other day his best market is Japan right now. Blackstone and Bain, same thing. Because you have an overall kind of protectionist construct of the Japanese economy. The activists have begun to change the Japanese economy, but there won't be a fundamental change. But this, like, here, shed non-performing assets, sell it to U.S. companies, that's that's a real change.
Let me come back to this in a minute. So there were two particular concerns that in the antitrust thinking of the prior administration or the current administration, one of which was the fact that thinking about the roll-ups of various small entities for a large national entity run by the PE firms, particularly in the healthcare area. And so there's academic literature that, for example, identifies that targets are specifically identified that are below the Hart-Scott-Rodino threshold for reporting, and there can be a PE strategy of essentially a roll-up that looks at a series of them and creates a large national entity. And this is occurring in, for example, many of the healthcare and the nursing home entities. And this was regarded as a significant antitrust concern, not just because of the competitive effects, but also because of the broader concerns about quality that were, some thought, involved in the new owners of these entities. And so I wonder if you guys have reflections on whether this priority, the current concern on this dimension will be pursued in the new administration. And Mike, you might have a better idea about that than others. What do you think?
Sure. So I think it will definitely be different. The last administration, the former administration, had in its remedies guide, which was sort of no longer existing or current, that in the context of a divestiture buyer, a private equity buyer may be actually preferred because it provides fewer competitive concerns than an acquisition by a strategic. And that was controversial at the time, because there is always some concern in antitrust law traditionally that a private equity buyer might not be able to run a operating company with the same level of expertise, efficiency, et cetera, operational know-how, which I think is some of what we were talking actually about on the last panel with CEOs and votes and whatnot, as a private equity buyer. And so that was controversial at the time. I think the sort of pendulum has kind of swung maybe the other way now. So the example that comes to mind is a couple of years ago I was hosting a panel for the ABA spring meeting. Sorry to bring up a rival conference, but it's in Washington, so it's very far away. And there were two people on the panel, and they were talking about this very concept. And they said, and this is a direct quote, go back and look at the webinar, they said, private equity kills people, quote unquote. And that, that's, I think, alluding to the quality concern that you were raising, but on a very extreme sort of position.
Right.
Both of those people are FTC officials right now. And so I don't think you'll see that in the next administration. There's always been a concern in antitrust about roll-up strategy. And let's be clear, lots of funds are doing roll-up strategies because there are synergies that are involved in that process in terms of harmonizing things. But I think it'll be a different perspective than the current administration.
Right, but what about this concern that some have expressed, that a lot of that again, there's been identified in the literature, the academic literature, that there's a significant fraction of deals, particularly in the technology and healthcare area, where the goal of the transaction is to eliminate a potential competitor. And again, the competitors at a size below the Hart-Scott-Rodino threshold, and so therefore there's some challenge in being aware of the transaction at a time when preemptive action might be taken, except there is a matter of concern, and I think there's been an enforcement approach perhaps rolling out to figure out what to deal with that. Again, is that going to be a concern going forward, you think?
I think it was a concern last time and will still be a concern going forward. So one way to think about that is some of the large technology investigations that are currently being litigated actually have that phenomenon within a monopolization case. And those cases, I think Maria made the great point, that those cases sort of started and now are continuing, and they'll still be continuing, just as we saw with, say, the Microsoft case many decades ago. It takes a long time to litigate an antitrust case. So I think that's one aspect to it. The other issue that you sort of raise is the sort of, as a general matter, the nascent competition, the nascent competitor issue. Maybe small, maybe doesn't even have revenue, maybe has negative profits, right? But they have potential, right? And there's sort of a tension in antitrust law, and we saw this sort of then, and we see it now, between sort of valuing the idea that an entrepreneur may need an exit strategy, right? May need to bring a company to a certain point and then get purchased by another company in order to have an exit strategy to encourage entrepreneurialism, and that it might be a different skill set to bring a company to point X and then to bring it to point Y.
Right.
And at the same time, on the other hand, recognizing that sometimes, particularly large or well-established companies, might see this happening and buy this competitor and knock it off and shut it down. And so I think there's a tension. I'm not sure there's going to be a huge difference in that particular issue. The HSR rules actually kind of try to get at that, the new ones, in terms of the information that they require,
Right.
and what is required to be submitted, and what the agencies presumably will look at, although it's a lot more paper, so the agencies may need more resources, and that's another issue we haven't actually talked about today. So I think that concern will continue. I'm not sure I'll see an immediate change. This actually goes to a point David made in terms of timing, which is,
Right.
We're talking as if this is an immediate issue, but there's, personnel takes time to get into the agencies. So.
Right. Question for you. What would you guess would be the new administration approach to the idea of breaking off Chrome from Google?
Well, I think he said, I don't know about that. We need really great American companies, and China's afraid of Google, and maybe that's a good thing. So, more broadly, to answer your question more broadly, the tradition is you continue to pursue, even with the change in administration, you continue to pursue the cases that are out there. I think what will change, again, sue, not settle, that I think that will change. And so a case that is in the works now that may be taken all the way to completion with this administration, maybe there's more of an opportunity to find a solution and find a settlement that works. And that may be one of them, I don't know, but others certainly will be.
Yeah. Maybe we ought to give the audience a chance to take advantage of the expertise up here. So the floor is open for, I think we have, time is
10 minutes?
10 minutes. Yeah, we have till noon, so that's a 10-minute time for you guys to ask stuff. I've got other things to ask, but I don't want to preempt your chances here. Yeah, Todd.
Hi, thank you for all this very valuable insight. I had a question. People have mentioned areas that they think are going to be of particular interest. And I'm involved in financial services, so I think of the Visa, Plaid, and other things around the payments, around fintech, less banking, which has its own world. But what do you think about, is that going to be an area of attention, or have we passed that point?
I think it will continue to be an area. I mean, the Visa Plaid case was brought by Megan. I worked on that too. So I think it will continue to be an area of focus, and there was a big suit announced against Visa pretty recently by this administration, and I think those cases will continue to be pursued. There's obviously a lot of money at stake. We use credit cards and other methods of payment multiple times a day. It affects every single consumer in this country, and increasingly that's being exported to other countries. And so I think it will continue to be a focus.
I definitely agree with that. The Visa Plaid was actually the case I was thinking about with respect to the nascent competition question. That was during my tenure at DOJ, and I think that you're more likely to see focus on the, well, for lack of a better term, fintechy space, as opposed to the what you described as the financial services space more broadly, given the sector regulators. There's an interesting question in every administration about how the sector regulators interact with the antitrust competition authorities. In the current administration, we have this sort of whole of government approach through an executive order that is attempting to try to bring everybody together. It's not clear whether that will stay the same, but there's always interaction, and some of it is personal in terms of how the people interact, and some of it is the priorities of the particular administration.
Yeah, come on up, Mike.
I've already yelled at Michael. How much more important will European antitrust and ESG legislation be for how American companies behave? To what extent is what's going on in Europe basically marginalizing the people on the panel?
Marginalizing us?
So I think obviously that's three loaded questions. I've been marginalized for a long time, so I don't take it personally. First of all, I don't view things as U.S. companies and other than U.S. companies. These are all global companies we're talking about. Visa generates more than half its revenue from outside the U.S., so I think it's a nonsensical dichotomy. If you look at all the big companies that will be before any government agency, obviously they have home bases, making it, what was the phrase, Ivan?
Redoing this.
Onshoring?
At home. I don't know what that means. I don't know what home means for Unilever, Procter and Gamble.
The last panel would say it was Delaware.
Yeah.
Or Ireland,
Right. Yeah.
but I don't accept.
So I think that,
Well,
go ahead. Ivan.
I also think it's where is the process? So
Yeah,
I'll-
exactly. Like, where's the centered process? Yeah.
I'll give you an example. Lumileds, a Dutch-owned company that was trying to do a transaction in the LED lighting space. The process to make an LED light, people from the national labs used to go to the Lumileds lab 4 times a year and work with them on a process. Lumileds didn't know at the time that what the people from the national labs were doing. Same process to make the LED light makes a trigger for a nuclear weapon, because it has to withstand high temperatures and extremely low temperatures. So they were going, and here, the folks from the Netherlands didn't even know. It's like, why did the national labs keep? So where you actually do something is important. And you didn't even mention China, because SAMR's probably done more to stop semiconductor consolidation than any other regulator in the world.
They stopped NXP Qualcomm. They stopped Intel Tower.
It's not going to
Not
make us
officially.
irrelevant. It's going to make our job more challenging.
Yeah. I think that's the net of it.
Yeah.
We're in a world of much more complexity.
Yeah.
Bottom line. So whether you like it or not, lawyers, whether I like it or not, lawyers are going to be needed, because this is a minefield, and one in which fine institutions like Columbia and the law schools have not yet prepared lawyers. To be perfectly honest, we talked about governance and boards. I just don't think there's an awareness of how boards actually run within companies. And as I said, how they think through these processes. They don't think about governance and regulation when they come to they figure out how they're going to make more money and how they're going to stay on the boards. And then they work from there. So I think it really does depend on where it's centered.
Yeah, and from an antitrust perspective, I don't know that the EC has been. I mean, they've been just as permissive or strict as the U.S. in some cases. I mean, they cleared Microsoft Activision, right? They've cleared deals that the U.S. has not cleared, and most of the time they come out in the same place. So I think there continues to be a lot of work there.
Yeah.
One thing we haven't discussed, which I think is important, is around the world, the rise of populism. And so how does populism affect the EU regulators? J.D. Vance loves Lena Khan.
Conservative.
Right? Conservative. Right? And I think that we're entering in this phase where populism is really going to impact how regulators look at it. And there'll be more political pressure on the regulators around the world.
Well, I mean, again, to come back to the issue as to whether the era of the global has ended. I mean, on the one hand, Dave is saying that European standard setting when it comes to disclosure on sustainability issues is going to be the critical driver of, in fact, what U.S. firms are disclosing because they want access to the markets in Europe. But on the other hand, I also hear statements to the fact that a lot of activity is going to be, there's going to be pressure to withdraw it even from Europe because of a decision that certain critical activities ought to be done in the U.S. So I'm seeing a certain tension between globalization type pressure and mercantile withdrawal, and so I just wonder what that's going to mean for M&A in general, I guess.
I'll use a live example for a deal that we did, which was kind of a 3-country deal, because I think involving a private equity firm, a European strategic, and technology that was Israeli cybersecurity. So Talos and Perva last year, which went through several different regulatory reviews, and went through, and I think you're going to see more and more of that. Like, all of the software development was being done in Israel. It was essentially an Israeli company, but headquartered in Palo Alto, owned by Thoma Bravo, bought by a French company whose shareholder base includes, a third owned by the French government and the other piece owned by the Dassault family. And we navigated that in, I think, some difficult times in post-October 7th time, and we got through. So I'm going to be optimistic, because even though my kids' education's been paid for.
Right. But I guess there's a lot of friction that you've described, right? And so if deals are going to be evaluated, I mean, even if FDI is going to be evaluated on national security constraints of a fairly tight sort that haven't been used in the past, if deals are going to be evaluated consistent with trade policy objectives, getting involved, not again in the laissez-faire space, but in government-to-government negotiation, it does seem to me that we're going to see a contraction. I mean, that one major change going forward is going to be contraction in the cross-border M&A space, and that will be question mark, a really big change going forward.
I think it puts a premium on having the right advisors.
sorry?
I think it puts a premium on having the right advisors.
Yeah, and I think it also puts a premium on not only the advisor, on the narrative and the compelling reasons for the deal.
The narrative.
That's really what. There are a lot of sloppy deals, and they were put together. I worked for a CEO who told me he had to do at least one deal a quarter to satisfy the analysts. And we got into a bunch of bad deals that later were written off as a result. So I think you have to be better. You have to have, and Ivan's description of that is going to be a typical triangulation of deal structure. That complexity.
We're back to great power competition. We've got a major shooting war in Europe. We've got a major global competition with the Chinese. And I do think there's actually an incentive, and I think even people within the Trump administration get the best Western technology and have Western champions. And I think that may trump, no pun intended, that may trump like the, America first, because at the end of the day, ensuring that we have hypersonic missiles, ensuring that we have the best kit in the West, the example I use with the French and the Israelis, there's nobody that does cyber better than they do. And bringing all of that into the system, I think that will probably trump all of the populism and the localism.
So a final question from Mike. There's been allusion to the fact that one of the concerns, non-traditional concerns of the Biden folks was the labor effects of M&A, right? And so I guess the question is, given the VP's, the new vice president's concern with working folks and the desire for expansion of political carry among that group, do you think that the concern about the labor effects of M&A might persist in the new administration?
Not in the same way. So there's, at this point, a consensus on some of the developments that happened at the tail end of President Obama's administration with respect to no poach, wage fixing, those types of issues, right? I signed one of the first no poach indictments at the end of the first President Trump administration. I anticipate that that would continue, and that focus on the effect of Section 1 or even Section 2 type behavior on wages or employees' mobility
Right.
is something that will definitely continue. So that, I think, is constant. I think is worth mentioning. In terms of labor and the effect on how,
Like monopsony theories of
yeah. So there's always been some concern on that. I'm not sure you'll see the same type of concerns as, say, a regulator in maybe, say, like a South Africa or an EU regulator might think, which is what we've seen in the past few years. But I do think there will be a focus on what is the effect of this on more than just sort of the traditional what would have happened 20 years ago in the antitrust analysis, because as I think it was Ivan mentioned, there is some convergence of the Senator Vances of the world and the Lena Khans of the world on some issues. So I think that can be harmonized within it.
All right. So I have two important announcements. One of which is that you're supposed to sign in for CLE if you want credit. And there's a table outside, right? And then finally, even more important, there's going to be lunch, which is the lunch is available across the hall. And please come back here by 12:15. Laurie will be in dialogue with Eric Talley, so that should be a great chance to hear what Delaware is thinking. We've heard what the Washington folks are thinking. Now we'll hear what Delaware thinks. And thank you so much for that discussion.